This is a really good question, and actually it's been asked of me several times this past week, ironically. So I want to give a quick history lesson because I've been practicing long enough to tell you what the difference is between how cases are handled now and how cases go to jury trial today as opposed to what went on maybe 20, 30 years ago. In Wisconsin, there is what's called alternative dispute resolution, ADR. And that has been on the books for a number of years, but I've been practicing long enough to tell you there was a time when ADR did not exist. There was not mediation. There was not a settlement mechanism built into the law that would allow parties by court order to be forced to sit down and try to settle their case. So when I first started practicing some 30 plus years ago, I'm practicing 33 years at this point, when I first started trying cases and I was initially practicing law, a lot of cases went to jury trial because there was no mechanism for resolution once you started a lawsuit. You would negotiate with the insurance company. Many times cases were settled without a lawsuit, but if you could not get the case settled, a lawsuit would have to be started, and usually once you did that, there was not any formula or mechanism to resolve that case, and it wound up going to jury trial. So it wasn't unusual that if you were a plaintiff's lawyer and or defense attorney, you were trying 4, 6, 8 cases, maybe 10, 12 cases a year, every year in practice. And then when they created this alternative dispute resolution statute, judges now are ordering the insurance company and plaintiff's lawyers to sit down with a mediator who's usually either a retired judge or was a lawyer practicing in injury law, whether it's a defense attorney or a plaintiff's lawyer, who is a skilled trial lawyer, to sit down with the insurance company and the injured party to reach a settlement at mediation. And many of these cases are settled now via ADR. Very few cases are winding up past going to mediation and not being able to settle the case, where cases are tried to a jury. So if you look at the statistics with the state of Wisconsin, you will find many cases are settled via ADR, and there are very few jury trials anymore in circuit courts on accident cases. Of course, there are times when a case just has to be tried to a jury, where all successful efforts to get the case resolved have failed. And of course, that's why there are courtrooms to resolve legal disputes, including injury cases, where jury trials have to occur. But I see fewer and fewer of them each year, and I believe from my discussions with many circuit court judges in the greater southeast Wisconsin area, they too see very, very few cases going to trial on accident cases anymore, unless it's a very significant case where a person has suffered serious injuries, fractures, permanency, disfigurement. Larger cases wind up still going to trial. The smaller cases usually are settled via ADR at mediation.